Okay, good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of April the 18th, 2013. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. At this time, I would ask everyone please either turn off your cell phones or put them on silent or vibrate so as not to disrupt the proceedings. I can tell you guys, probably from where I'm standing this way, there is no cell reception, so that may not be an issue. The procedure will be to introduce the case record as the Codes Department has it, and we'll do that on the wall here by means of a PowerPoint presentation. We'll present any maps, site plans, photographs of today's cases. We'll also present any letters that we've received in support or opposition to a case, as well as any correspondence we received from other government agencies. At the conclusion of my presentation, the applicant will come forward first to the table, along with any persons in support. And if there's opposition to a case, the board will then hear from those parties opposed after the appellant goes first. After the oppositions presented their testimony, the applicant will have a period for rebuttal. The board in their rules provides applicants in cases without opposition 10 minutes to present their cases to this board. Where you're sitting here to your right will be that clock on the on top of the countertop there. That'll keep your time. It will run during your testimony, but it will be stopped for any questions the board might have for you. In cases with opposition, the board provides 15 minutes for each side, so that's per side, not per person. So if you have multiple speakers, you need to divide up your time accordingly before you come up. All section numbers that I refer to today come directly from the Metropolitan Code of Law in Title 17. Title 17 was adopted by the Metro Council and became effective on January 1st, 1998, and applies to the entire jurisdiction of Metro government. I'll introduce and make a part of the record zoning code, a copy of which is kept here at my desk, and I'll dispense from reading individual sections unless the applicant or opposition requests that they be read. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board come forward. On your desktop there is a microphone stand just like mine. The button on the right is the speak button. You'll notice the red light comes on your microphone like mine is. Your mic is hot. Then give your testimony. When you get done speaking, please, if you'll turn that off, I'd appreciate it. It should be noted that it's found anyone's presented false or misleading testimony to this board that may have affected the board's decision. Any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and then after each case, the board will then discuss and vote on that case. The board is vested with the power to act before us under Section 1740-180 of the Metro Code. The code requires that 4 members of the 7-member be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. Today, we have all the members present, have 6 members currently. You need 4 of these 6 members to approve your case. In the event of a tie vote, that would be a vote of 3 for and 3 against. Your case will stay on our agenda for the next 30 days. Any of the members that participated are allowed to change their vote. If none of those change their vote within 30 days, your case is deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, any appellate or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within the same 60-day period, but once 60 days has elapsed, this board's decision is final. No further action may be taken. If you're an applicant and your case is granted, it is necessary for you to obtain the permit for which you've applied. You have 2 years from today's date to pick up your permit for this approval to remain valid. Mr. Chairman, I submit that all cases were filed in proper order. Appellants were notified by certified mail as required by the zoning code. All affected property owners within 300 feet were notified by first-class mail, and a legal ad was published in the Tennessean. But before I begin, I do have some preliminary announcements. Starting with the on the front of today's docket, case 2013-3. West End Development Company has withdrawn this appeal. That withdrawal is without prejudice. They can refile it at any time. The second announcement I have today is case 2013-38, the Monroe Street United Methodist Church requesting a variance in the street setback for a sign. That case has been withdrawn by staff. There's no appeal needed for that sign, so that case has been withdrawn and will not be heard. That's case 38 at the top of page 4. And Additionally, on the same page 4, case 39, JK Construction, 2106A Sunset Place. They were requesting a variance in the landscape buffer yard. They have withdrawn their appeal. So that case is withdrawn. That case is withdrawn with prejudice, and there can be no new appeal for the same items for the next 6 months.
You said 39?
39, yes, sir.
And
at Sunset Place.
Was that the only thing that was being appealed?
Yes, sir.
Okay.
And then additionally, on the last page, page 5, case 2013-20, Miss Melanie Morgan, the appellant, St. James Baptist Church at 600 28th Avenue North, requesting a special exception to use the church as an adult daycare for 75. The applicant has withdrawn that case. That case will not be heard today. It is withdrawn with prejudice. So, again, no appeal for that like request can be filed for 6 months on that property. So cases withdrawn, case 20 on page 5, cases 38 and 39 on page 4. And case 3 on page 1. Additionally, I have a request by the applicant in case 40. It is the appellants are Joshua and Ashley Travis. Their representative is here. This is at 118 Brookfield Avenue, requesting a deferral 1 meeting to May the 2nd. Is there anyone here in opposition to case 40 over on Brookfield Avenue?
We were requesting the 16th.
Oh, 16th. I apologize. Yes, you did tell me that. I'm sorry. That request is to May the 16th. Any opposition present on case 40 on Brookfield? Mr. Chairman, seeing none, I do need a motion and a second from you guys on that to defer that 1 meeting.
Motion to defer. Is there a second?
Second.
Got a motion second. All in favor?
Aye.
Any opposed? Passes.
Okay. All right. Case 40 is deferred till May the 16th. And, Mr. Chairman, that's all the preliminary announcements I have.
Could you run down the cases that were withdrawn?
Yes, withdrawn cases are case 3 on page 1, cases 38, 39 on page 4, and case 20 on page 5.
Okay, thank you.
Okay, before we begin our meeting, the board in their rules allows elected officials to address the board should they wish to. Are there any elected officials present today? Mr. Chairman, seeing none. Okay. The board does have a consent agenda, and prior to the meeting, a board member reviews the case in each record. And if, in their opinion, the appellant meets the criteria for the application requested, and they feel that testimony would not alter the material facts, they recommend the case to the remainder of the board for approval. I'll now enter into the record those cases that have been recommended for the consent agenda. And if you are here in opposition to a case, in opposition only, please raise your hand, and your case will be heard in its regular order on the agenda. The first case recommended for consent agenda today is case 2013-35, Mr. David Estrin, 2805 Lone Oak Drive. Mr. Estrin is requesting a street setback, variance in street setback to construct a new addition to his home. Is there anyone here in opposition to case 35 on White Oak Drive? Mr. Chairman, seeing none, the exceptional shallowness of this lot is the hardship that necessitates a need for a variance. That case has been recommended by Mr. Whitson for consent to the board. The next case recommended for the consent agenda is case 2013-36, Mr. Michael Ball, 3304C Felicia Street, requesting a variance in side setback to construct a 10-by-14 addition to the rear and a 3-by-14 addition to the side of the residence. Is there anyone here in opposition to case 36? Mr. Chairman, seeing none, the exceptional narrowness and topography of this lot necessitate a need for a variance in this case. That case has been recommended for approval on the consent agenda by Mr. Whitson. The next case recommended for the consent agenda is case 2013-37, the Orchard Foundation at 400 Jameswood Court, requesting a variance in the rear setback to construct a sunroom. Is there anyone here in opposition to the request on Jameswood Court, case 37? Mr. Chairman, seeing none, the exceptional shallowness of this lot and irregular shape necessitate the need for variance. In this case, Mr. Whitson has recommended that case for the consent agenda. And finally, today's consent agenda, case 2013-41, Mr. Derek Crownover, 1701 18th Avenue South, requesting a variance in rear side setbacks in RM 40 to construct a detached garage, referred to the board under section 17-12020. Is there anyone here in opposition to case 41 present who is opposed to this case? Mr. Chairman, seeing none, the topography of the lot necessitates a need for variance in this case. Mr. Whitson recommends that case for consent. So recapping, cases 35, 36, 37, and 41 have been recommended for consent by Mr. Whitson.
Okay, so we've got a motion for consent. Is there a second?
Second.
Second. Any opposed? And all in favor? Aye. Any opposed?
Joey, I think we had a question.
Sir. Give me. That case will be heard in its order. Yes, sir. Okay, if you are here for cases, the board has approved the following cases for consent. Case 36, 37. I missed one here. 35, 36, 37, and case 41. Your cases have been granted. You are free to go. The remaining cases will stay. We'll hear the first case today, and that will be case 32 will be the first case before us. And the appellants, if you'll come forward, the applicants for case 32. And as this gentleman comes forward, sir, the procedure will be I'll show the photographs and let the board know why we've denied the request, and then I'll turn it over to you to give your presentation, okay? Well, no, we denied your permit. That's why you're here today. Yes. Sorry about that. I should be clear on that. Is there any opposition present to case 32? Okay, no opposition present. Sir, let me go through the photographs and the drawings here, and I'll turn it over to you. Okay, this case is located on the northwest intersection of Whites Creek Pike and East Nocturne Drive in the Bordeaux area. You see the subject property is zoned RS 7.5. It is the property that's bound in red here. This is an aerial photograph of the property of the subject site. And then the application submitted by the appellant on this case. The existing residence, the request is to take this residence and convert it to a church use. The existing residence, as you see, located on the property. The proposal is to also install a surface parking lot in the front of the property. This parking lot will be paved and striped, as noted. Our office denied the driveway width, and that's the variance that the gentleman's requesting in this parking aisle to 20 feet is what is shown. 24 feet is what's required, the width of that driveway. This is looking at the subject property today. I believe the home is vacant. Is that correct, sir? Is it home's vacant now? Looking at it from Whites Creek Pike is to my back. East Nocturne, as you see on the right-hand side of the photograph. The parking lot would be located in this area here. These are the neighboring properties on the corner. Across East Nocturne is a non-conforming grocery store or market that's recently closed here. That is a legal non-conforming use. And then adjoining property is this stone house on the north of the property here. And you see their driveway for that property and parking area. This is looking at the subject property. I'm essentially standing at the intersection of East Nocturne and Whites Creek Pike looking into the site. This is a change of use for us, and there's no construction going on as far as additions to the structure at this time. So members, you might note there's no sidewalks required either here. Just a simple change of use using the existing structure does not trigger any sidewalk provisions along Whites Creek Pike. Should there be some additions in the future, those may be required. And the driveway would approximately come in about where my public hearing sign is. Parking area will be in the front. All right. That's the case as we have it. With that, I'll turn it over to the gentleman there at the table. And, sir, if you would please pull that microphone a little closer to you and identify yourself and make your presentation.
Yes, good afternoon. My name is Hector Rogo, pastor of Iglesia Evangélica de la Fe Apostólica en Cristo Jesús. It's a Spanish church, and a very small church right now, and we're hoping to grow. And like Mr. Joe showed the property and everything, our plan is to rehab and convert that existing residence into a small Hispanic church with 25 seats in the sanctuary, and really don't know what else to say.
Can you pull your microphone a little bit closer, please?
Sure.
Thanks.
Okay. I really don't know. He technically, Mr. Joe technically spoke and showed everything that needs to be shown, really. Like I said, we're just a small church, and that we're hoping to grow, in that community. And right now we're about 19 people, maybe, or 18, something like that. So it's very small.
How many days a week will you use the church, and which days will that be?
We use it on Saturdays and Sundays. Mm-hmm. So there will be Saturdays and Sundays in the evening.
Both Saturday and Sunday in the evening?
Yes, sir.
Okay.
Have you seen the Planning Commission's report?
I believe I did, yes.
Okay, because they recommend 3 conditions, and if you've seen it, I don't want to bore everyone, but the first one is they would request an appropriate landscaping buffer and screen of the proposed parking area along the north side, which abuts existing residential homes.
Yes, and I have that taken care of already.
Okay.
You have a plan ready.
You could see the landscaping on his plan. Yeah.
Okay, and then they also would prohibit direct access to Whites Creek Pike, which it doesn't look like you're trying to do.
Which we changed it back in Nocturne. That way it wouldn't happen.
Okay, and then the third one is the zoning code provisions for lot coverage and impervious surfaces for residentially zoned areas shall be adhered to for this use. My question is, are you willing to accept all of these conditions?
Yes.
Okay.
So is the reason that you don't have the 24-foot drive lane the front setback that you're trying to adhere to, or is the reason, is it an existing curb cut? I mean, why can't you just add 4 feet to the drive lane?
No, that's not a problem. I did not even know that there was a difference, or was there a problem with that specific width. So, that can be
okay.
fixed on the blueprint.
So Joy, if they make it 24, he doesn't need the appeal, right?
Yes, sir, that's right. If the plan's redrawn, we can strike that.
And if it is 24, does he get any kind of setbacks? Or
Not at all. No, parking's permitted to be in a setback, so there would be no issues there.
So in theory, the applicant could scratch off the 20 and put 24 feet there, and it would be...
Yes, sir. And if he's willing, if you'll just redraw that and make it 4 feet wider,
problem.
that's fine. We'll just withdraw that.
So we could move to withdraw this, or to...
Do you understand what he's saying? He says basically if you widen the driveway an extra 4 feet, you don't even need our permission.
But this
No, we still need a
use,
special exception, I
Yes,
think.
the use still needs
Right, you don't need our variance. Yeah, the
right,
use,
You
yeah.
don't need a variance.
You don't need the variance, but you need the...
Okay.
So you agree to redraw that, sir? Make it wider and width?
Yeah, we'll make it wider. That's not an issue.
Okay.
You guys don't need the motion. We'll just administratively withdraw that.
Okay, so then well, I don't want to jump ahead, but that was the only question I had.
So do we have any other questions? Okay, sir, unless you have anything else to say, I'd close the public hearing and we'd enter into discussions, if that's okay. Okay, great. Close the public hearing. Well, just to recap, I mean, it's a special exception as to the use, and the church is willing to live with the Planning Commission's 3 conditions and redraw to make the entrance 24 feet. So I would.
And our standard is that it is, not to be too legal about it, but no worse for the wear for the neighborhood. It doesn't have any negative impact.
Right.
Actually, I think it's probably positive for the diversity of the neighborhood. That area.
Okay, so I would make a motion that the board approve the special exception permit because it meets all the requirements of MCL 17.16.50 with the additional requirements that the church meet the three conditions in the Planning Commission's recommendation of approval, and that the driveway or the entrance be redrawn to make it 24 feet.
I'll second.
Okay, we've got a motion, we've got a second. All in favor?
Aye.
Any opposed? Passes. Congratulations.
Congratulations.
Your case is approved on a vote of 6-0, and I think I left out of the preliminary announcements. So for the other applicants that are here, that this board's approval, again, good for 2 years. You were given a checklist of items. Other conditions, go ahead and proceed with obtaining those approvals, and be sure to come by our office and pick up the permit once it's ready. But with that, case 32 has been approved on a vote of 6-0. Thank you both.
And you're welcome to stay, but feel free to leave. We understand.
He's got a driveway to widen.
Okay, next case before us is case 2013-33, the McGowan Limited Partnership, the appellant and owner of the property at 2151 Ackland Avenue, requesting a special exception in RM40 and UZO. This request comes to you as an amendment to the previously approved plan to reflect 16 units. The prior approval was for 20. They're referred to the board under Section 1712.035. The appellant has alleged the board would have jurisdiction under Section 1740.180, item C. The applicant's present. Is there any opposition present to case 33? Okay, Mr. Chairman, seeing none, let me pull up the drawings and go over my part of this appeal. The subject properties are located here at the southeast corner of 24th Avenue South and Ackland Avenue. Again, it is in the RM40 zoning district and the UZO. These three lots would be consolidated. An aerial photograph showing the subject property across the street, Fannie Mae Dees Park. I believe the Ronald McDonald House is just south of this location. I'm going to switch first to the plan that was previously approved by this board. The board in 2012 approved a site plan and elevations, which you see here. It was approved for 20 units. That appeal and approval runs with the land. About a year later, the applicants approached and asked to redo their plan, and under your rules do grant our office the authority to make minor deviations to the plan. As you see, this site plan versus the site plan submitted by the applicant, that to me was not a minor change, was a major change. And it's effectively amending that prior approved plan to reflect this new plan. You see the differences. I'm going to switch between them, the site plans. The prior proposal included 20 townhome units arranged along 24th and Ackland, and then along the eastern property line with parking coming in off the alley, 90-degree spots here, and then 3 spots that Public Works approved to utilize off the alley with the dumpster located here. This plan proposal, again, to utilize some parking coming in off of the alley here. The driveway entrance would be off the alley. Parking would take up the right-hand portion of the eastern part of the plan, and then the new structure, 16 units, whereas you saw the 3-story units roughly there, this would be a 4-story venture here at this location. The building itself, the board approved a setback off of 24th for 7 feet and a setback off of Ackland at 0. This plan would pull that building away from those lines, clearly off of Ackland. It is within a foot or so. They do have a covered stoop that comes in off of 24th here. They're within a foot or two of that setback there. I do list sky plane on here, at least the preliminary measurements that we made of his elevations. It looked like a small corner of that building penetrated the sky plane. It may not be once the construction sets are submitted. Part of that was parapet, which is actually a permitted sky plane obstruction. But for today's purposes, I wanted to list it there. Indeed, if there was some issue with that, they wouldn't have to come back and seek approval. Notice on this plan, and we do have a letter in opposition filed about the dumpster location along Ackland Avenue. For us, dumpsters are not a permitted setback obstruction. We need to look a little closer at that to see if that location needs to be modified. The appellants, I believe, have had a neighborhood meeting and discussed this plan with the neighbors, and I'll let the applicant cover any kind of changes to this plan that may have been born out of that meeting. And these are the elevations submitted. This elevation is along 24th Avenue looking east, and then this view from Ackland looking south. Again, the parking lot would be behind this area here.
So about the trash enclosure, are you saying that you're not sure if it is or is not allowed?
Dumpsters are, well, see, you're in the UZO, so your setbacks do vary quite a bit. This board actually granted permission for the prior structure to be at 0. Dumpsters aren't envisioned in that. They are subject to the same setbacks that a structure would be on that. I need to run some numbers on it to get the exact, I believe where it's located actually would comply with the code. I need to double check that.
And I'm sorry, what did we approve again on Ackland?
Approved on Ackland at 0, based on that drawing.
But okay, so if it's within the setback that we approved,
well, that's I'll have to kind of talk with the zoning administrator about that.
It used to be on the alley.
Yeah, it is something just like a building has to comply with the setback on the street situation. I'm comfortable with allowing a building, at least on a minor deviation. If it was within the setback you granted, they could move the building a little bit as long as it met that setback. Dumpsters, we never really spoke to that in the prior appeal, but I do want the appellant, and I believe they're going to address that to you here about where that's going to be located in that. This is looking at the subject site on my visit out there and putting up the public hearing signs. The existing structure out there is now vacated. Some demolition has begun to occur.
I think it's all gone.
Is it all gone now? Okay. All right. So these are a time capsule then of what was there prior to the day. And you look at the existing structures that were there. These are views across. This upper left photograph is kind of to the northwest, looking at Fannie Mae Dees Park. To the southwest, here the Metro Public School property, and then directly north of the property on Ackland there. And then the view from 24th Avenue. And I'm going to bring back up the site plan that's been requested here. And with that, guys, again, any opposition, no opposition present to case 33, I'll turn it over to you all. Again, for the record, you did receive Planning Commission recommendation, letter in opposition, and let's see, did I miss anything else? Is that okay?
Before you get started, I just want to kind of prompt your testimony into this direction. And we obviously approved the last plan. We were very impressed that you had the council person supporting it and 2 neighborhood representatives from the neighborhood groups presence. And that's sometimes hard to do, particularly in my neighborhood. But you have a new plan. So how do we get from last meeting to here?
My name is David McGowan. I'm owner of a company called Region Homes. We've developed a Lennox Village community here in Nashville. We've also developed quite a few buildings in the West End Park area. We were one of the first ones to build a building in the West End Park area. The previous individual who put it property under contract had basically envisioned a community that he would build townhouses for rental purposes. I'm sure you realize that the rental market has heated up quite a bit, and there's probably a little bit of an oversupply in that area, as well as the banking conditions have changed, and so after looking at it all, he decided he would maybe look at selling the property. So we came in as the buyer and we purchased the property. He still has a minority interest in this piece of property, Kevin McGeehan, and decided to look at what we thought would be appropriate for the area. We are building a for sale building. It's not a for rent building. We consider it a AAA class building. It's an elevator controlled access building. We told the architects we wanted something to be what we considered a Jacksonian look to go in that particular area. And so knowing the employment base that's at Vanderbilt Hospital, knowing the desire to be able to get away from the automobile to limit your carbon footprint and all, we then conducted our own market study, and we developed this particular building with the architects Smith G. And Associates. We think it would be an appropriate building in that area. We think that area is prime for that, very similar to the West End Park area. And again, we built 3 buildings very similar to this in the West End Park area. One's called Ruby May, one called Artie Lee, and so this particular building here we think will be very well received. We had a community meeting. We had about 18 residents show up. The only issue that they wanted us resolved was the dumpster, and they wanted us to move it to the alley. We've asked the architects to look at it. Originally, the dumpsters, we had a dumpster for trash and a dumpster for recycling. Right now, a dumpster for trash works very well. We've actually have contacted the waste people about putting a different type dumpster for recycling there that would be a smaller dumpster. And it's understood that we think that when we go for permit, we will be able to move that dumpster from that particular location. Some of the things the neighbors were concerned about, what kind of wall and screening we were doing for the parking. They were able to understand it was not a wooden fence. It's actually a brick wall that matches an existing brick wall on the adjacent piece of property. And so that's how we got here. We have a very strong interest. We've already had some news articles come out about this particular building that we're proposing, and we've got quite a bit of interest for this particular area. This is Andy Berry. He's the architect for the building, and I don't know if you want to add anything to that, Andy.
Sure. Shall I show the site revised site plan?
Yes, please.
Okay. Here you go.
You got this one here?
That's the original.
Do we have any questions as the site plan's going around?
Well, so does the wall remain?
Yes, sir.
And is the transformer going to be behind the wall?
Yes, sir. We will have a wall.
I didn't notice that when you passed around. Sorry.
There is a restriction about how much wall we can have, but I do not believe that the wall will be along Ackland. It'll actually just be along the side of the part of the transformer.
So I'm sorry. So the wall continues all the way down Ackland on the property, or does it stop at the transformer?
All right, to that point, this shows the transformer's on the outside of the wall.
It's not even in a wall at all in
sitting
the previous plan. That's why I was asking if that could be.
Go ahead, Andy.
I mean, I know there has to be a certain amount of clearance.
Yeah.
Yes. We need to verify the clearance for that transformer there.
Okay.
It seems like we actually cannot put that transformer behind a wall there because you've got to have service access. We've had that happen on a few projects that we end up having to stop a wall shy of a transformer. So that's how it's shown. Is it keeps on going right through Ackland there.
Well, right. There might not be enough room once you put the fence around
open
it
area
without losing the park, and I was just curious about that.
Sure.
I know you don't have much say in that. I was just. Do you know how big this particular transformer is?
I do not know off the top of my head. It will be a riser pole set at that location. If you went out to the site right now, you would see it cleared. The large pine that was set on the corner, 24th and Ackland, we saved. We also saved the other tree in the back area there. And we're asking the city, and the power company's already agreed that there's a pole right at the basically where we have a bike paths and one over where we had the handicap off the alley. And they've agreed to move both of those poles, and we're paying for a riser pole to be placed at the corner of the property on Ackland where the transformer is, and then go underground from there. And I think that the biggest thing with the city in Middle Tennessee, not Middle Tennessee, like Nashville Electric, they require a 20-foot buffer from the center of it around that transformer. And so I doubt if it would be more than about a 4-foot box, from our previous experience.
And there's no sprinkler, or is there any backflow preventer or a hot box for that on site?
We will have a irrigation on the property, and the building will be fully sprinkled.
But I was more concerned about if there would be an enclosure for that wasn't shown on here.
It's not shown here, but we would definitely have a irrigation sprinkler system. We've been able to work with the powers to be in the water department. If you look at the door that's on the corner that faces Ackland, we normally put our riser rooms and our sprinkler controls in those particular areas.
Okay.
So they do not have to be in a box. We
So there won't
keep
be
that particular
a pump house or a...
Right.
Mm-hmm. Okay. All right. Thank you.
We did market study, and the existing buildings that were approved were very small, about 1,000 square foot units, and it really is a dorm type unit. It's not a unit that would be basically sold for living purposes. And we feel that a 1,500 square foot 2-bedroom unit more addresses the demand for the market in the place there. And we estimate these will probably be selling somewhere in the high 3s to the very low 4s.
Really? Wow.
Mm-hmm. That's what the market currently is supporting in that area.
And so the decision to have the drive off the alley instead of Ackland, tell me why that was made.
We think that overall that if you went to properties, there are a few that do have access off of Ackland. We think it would be just a better looking building if we do have the brick wall there and then bring it off the alley, which will, if you actually talk to the neighbors, they will tell you that there's a little bit of traffic concern on the traffic coming off of Ackland on the 24th at certain times of day, and they felt like that it would be a better fit for us to come off the alley.
Any further questions? Unless you had anything else to say, I'd probably move to close the public hearing. Okay. Public hearing's closed. Discussion?
I'd like to commend the applicant again, actually. As we said last time, they had the support of the 2 neighborhood associations and Council Lady Berkeley Allen. And this time they have kind of taken a step back and looked at the market and changed their design, and I think submitted an even better plan. We're not here to look at architectural plans, but my personal opinion is this is a much better plan than the plan they submitted last time, and I think they did their homework, and I think it's good.
Yeah, I agree. I think that the plan is nice. I personally like it better. Also, the only thing that comes to mind when I look at it is that we had a really, really long discussion about the variances when we first granted them with the other plan, and it has nothing to do with this plan. It only has to do with with something when I was reading this, and I think this is more for our board and not this case, so I hope I won't deviate too much, but to think about when we approve projects, we basically gave variances to this piece of property that the person who we gave the variance to for a very specific project, decided he didn't want to do it for whatever reason. That's fair enough. Pass it along to another person, and those variances held. And had this project come independently, I would be fully supportive. So it's not any comment about this specific project, but it is about a little bit of uncomfortableness I have with some, blanket variances that aren't tied to projects. And so it's just something I would like for us to consider as a board. But this, and again, sorry to deviate too much from that, but as this specific project, I think it's a great addition to the neighborhood.
Joey, can you kind of talk about what David just said as how we approved it last time? It really ran with the land. It wasn't owner specific.
Yeah, well, the appeal did run with land. There's I believe, and David and I have talked about this. There is merit to what he says about, if someone's brought a plan to you that here's what I'm building and here's why I need this variance, and the next they turn around and they have the variance and then build something completely different. That may have weighed into your deliberations on the aesthetic. Now, to the extent it should or shouldn't. I think legal minds may disagree on that. I think you should be, and you do have a couple remedies for that. You can remedy it to this appellant, and that way if it's sold or transferred, that new buyer comes back and asks for something else. Or you can put a time limit upon it where you feel that, we think if this project doesn't get out of the way in a year or two, maybe the next guy needs to come in here and ask again.
But but Joey, the default position of this board, if you will, is just it runs with the land. When we approve one of these variances,
case law, and yes, your variances run with the land unless you specifically condition that.
But but to be fair, it's not as if we get stuck with just the parts they want. I mean, they're back before us asking for a change, which we could vote against. It's just in this case, we think it's better. So it's not as if the first developer could stick us with the parts he wanted and walk away. So I mean,
right? But it is conceivable that somebody could ask for a setback variance because look, this lot is funky shaped and it's too small, so I can't build anything unless I have a 10-foot setback instead of a 20-foot setback. But there's no specific plan, and a lot of times we raise those questions like, but what are you planning on doing? So if we said, okay, you've got the setback variance, but then anybody could then build whatever they want, and that's I think a more dangerous.
Well, I think there's a history of this with this board, and I think there's a cautionary tale I'm going to tell you as well. We had a case once over, I believe, on Harvard Avenue, and it was a rear setback variance. In this house, he talked to his neighbors, and his neighbors were not opposed to it. Showed this board a plan. Here's what I'm building. Here's why I need this variance. And you all found a hardship. Part of his deliberation was, I talked to my neighbors. I have this huge bamboo tree line at my rear property line, and I'm going to keep that. And he left here, submitted a different plan at the Historical Commission because it had to be by them, and consequently cut down all the bamboo trees in the back, which is why the neighbor never come. So she subsequently filed a rehearing request, even though she wasn't a party there. She was like, I didn't come because he promised to keep this land back here. So you may have that from time to time, that the plan they show you really is the plan that they need to be building. The cautionary part, I would say, if you run into a situation where the variance has nothing to do with the structure at all, that you get into deliberating about what's being built when we're just talking about the dirt itself. So just be careful with that. But there is a history of that. So I kind of advise you as your secretary, if you have concerns about this, I'm comfortable with you, sir, and not the next guy. Think about that in your motions if you wish to condition it upon an individual or a time limit. It does have to be reasonable, and the courts will tell you that, so be reasonable with your conditions.
And I guess I understand the position about the dirt and not the structure, but we sure do spend an awful lot of time with neighborhoods and council people and everybody else, and I haven't heard anybody ever come to us and say, I'm concerned about the dirt. It's always concerned about the structure.
True.
And so I know that, so not to, I understand that there's a little bit of gray there that we have to deal with.
Right.
And the reality is we have to deal with it because that's who shows up for our hearings, and that's what's on their mind. So anyway, that I think I was responsible for this distraction, and I apologize. I've passed, as I mentioned to Joey earlier. I've been on the board just a little over a year, and I'm starting to pass projects that, or let's say land of projects that we've approved that now are for sale again, and it just causes me to wonder, like, well, did we just increase the property value there, or I understand things go bad. I understand that it's better to ask permission before you do something, and I don't have any issue with any of that stuff. But it really started to make me, think about those types of issues because I think they're important.
I guess I would have to add that the old adage that good things come to those that wait. I voted against this first go around. I'm greatly impressed with this change, so I'm for it now.
All right, so just to wrap this up, we have Planning Commission approval, we have Public Works approval, we've approved it, and they're cutting back the density. So I would move that the board approve the special exception to amend their earlier plan and that it all complies with MCL 17.16.150.
I'll second.
Okay, we've got a motion, got a second. All in favor? Aye. Any opposed? Passes.
Well done. Good job.
Thanks for letting us use part of your time to think about things.
All right, that case is approved on a vote of 6-0. Mr. Berry, I apologize. I scanned the wrong plan. I apologize for that. That is my error on that one. All right, let's see here. I'm just happy I had access to email to be able to retrieve that.
Part of housekeeping, the plan that he submitted with the revised dumpster location is now the location.
Is now the plan, yes, sir. It is. Yes, because on special exceptions, as a matter of course, you are adopting that plan. That plan does run with your special exception, so versus the minor deviations which you've granted our office to do. The next case, and we'll call that one here, will be case 2013-34. The appellant I see is approaching. Any opposition to this case? All right, seeing none. Let me go through the record here first. Parthenon Development Partners, the appellant owner of the property, is located at 1801 McGavick Pike. They're requesting a variance in street setbacks in the RS 7.5 district to allow the subdivision of parcel 229, which you see here in red, into 4 parcels, which you are now on your screen before you. The request is to reduce the setbacks under the zoning code from 40 feet down to 30 feet. This is referred to the board under section 1712.030A. The appellant has alleged the board would have jurisdiction under section 1740.180, item B. This request comes to you somewhat via the planning department. The applicant has filed a subdivision plat with the planning department. On that, you'll make a note, and it may be hard to see right there on the screen about where my cursor sits, is a note on that requesting a 30-foot minimum building setback line. McGavick Pike is a collector street and requires a minimum of 40 feet. Currently today, there sits a structure on the residence somewhere between about where lots 2 and 3.
Joey, you went over that kind of quickly. Can you kind of explain the difference between a connector street and the others?
Yes. The major, sorry, David, 17 years of this, I think everybody should know this. Collector streets are classified under the major and collector street plan as busier type streets. They're feeder streets from the neighborhood where the folks live. This would be the streets that channel those to the arterials like Gallatin Road and Murfreesboro Pike. Those are your main arterials into the town.
So those have greater setbacks.
They do have greater setbacks for residential and commercial now, setbacks based upon that street classification. So McGavick Pike, as you'll note here, is listed as a collector street. Meaning this is a street that channels traffic from Riverwood and RD and all the other neighborhood streets there to get folks toward Gallatin Road. So with that being a collector street and being in the RS 7.5 district, the zoning code calls for a minimum setback of 40 feet on these lots. 40 feet, as you'll note here on this plat, the short dashed line is a 20-foot public utility and drainage easement that will be placed on this plat, and you see the proposed line here. So if you'll just double the length of this 20-foot, that would put the 40-foot setbacks in here. These lots would have a 40-foot, under the zoning code, have a 40-foot front, a 20-foot rear setback off these rear lines that are here, and then 5-foot internal setbacks until you reach Lot 1. Lot 1 would have a 20-foot setback because RD is not a collector street, and that's the minimum setback for RD.
So that's the difference. If it wasn't a collector street, it's 20 feet.
It would be 20 feet or the average of the homes to either side, whichever's greater.
So one is kind of exempt, but the others have to be 40.
Right, and that would come into play as this residence here would factor in to the setback of the home here. In a new subdivision, that would be in an existing lot. In a new subdivision, when this lot's subdivided, you'd look at the base setback to set the new home here. It's not an infill type situation. It's a new subdivision.
What's the current setback, Joey?
The current setback out there now is 20 feet. Well, it's 40-foot minimums. Upwards to 80 feet, depending on the average of the homes to either side.
Where's the home currently sitting, though?
This one here?
Yeah.
I would be guessing probably 35 or so. I don't know. I'm taking just a stab at it when I visited the property.
Okay.
So are you saying that Lot 1,
this lot,
is facing RD?
No, it'll face McGavick as well.
Oh, okay.
So it'll have a 40-foot front setback under the base zoning, a 20-foot side street.
Oh, okay. I'm sorry.
Setback,
All right.
20 here. Well, actually, greater than 20. On these lots, as you'll note, there's a sewer line that runs currently through this property that you'll see here. And there's a sewer easement built into that, and that's a 20-foot easement around it, 10 on each side.
So that's Metro's easement?
Yes. That ties into the main sewer line right back up and heads north in this location. So you've got this sewer easement that runs along the rear of the property in this area, and then back on lots 1 and 2, there's a creek and you'll see in the photographs where it meanders through the property and goes under RD and picks up there. So the request is to reduce these setbacks down to 30 to allow these homes to be pulled away from those easements. And then obviously on these two lots to be more uniform with the two up front. The existing home on the residence is a vacant structure. Upon my visit out there, actually the front door was off of it. This home's going to be demolished. The rear of the property entrance, as you'll notice, these garage doors were open. It appeared that perhaps the current owner or the prior owner had removed fixtures and taken things out of the home before it gets demolished. This is looking, let me back up. This view is east along McGavick Pike. Directly across the street from that, you saw in the aerial photograph, is church here. This home to the south is this residence looking here. And then these would be views into the subject property from McGavick's at my rear, looking back toward the rear property lines of these. The current property boundary follows just on the other side of this creek, dog legs to the left, and then back to the left-hand side up there. Those two farther lots, as you saw on the subplat, are deeper lots.
I'm sorry, Joey, you may have said this and I missed it, but isn't there not just a sewer easement issue, but also a drainage easement? Right?
Well, there's a there's a drainage easement that runs with this. I don't know what the actual classification of that stream, whether it's a blue line stream. The easement that runs in this area is just a public utility easement.
Yeah, I think I misspoke. I mean, but the issue's not only the easement, but it's also the drainage as well, not
yes.
the drainage. Okay, thank you.
Along lots 1 and 2.
Double hardship.
All right. That is the case records. We have it. I'm going to leave it on the proposed subdivision plat here and turn over to the appellant. You'll have 10 minutes to present your case to the board.
Thanks, Joey. My name's Jamie Reedy with Pantheon Development. I actually brought some pictures for you. In addition to In addition to the sewer easement and kind of the drainage issue that we're working with, there's also we'll call it a live spring that comes up from the earth that really doesn't show up on any Metro Water Services or stormwater maps. If we had a view of the previous picture where it kind of showed the stone line channel as it comes into RD, that actually extends pretty much straight back towards all the way across the property. There's just really no recorded easement or any type of documentation that reflects that. So it's really just kind of exists and nobody really knows exactly what it is. In addition to that, like Joey was saying, the home as it currently sits is about between 30 and 35 off of the lot lines, and as you hit the house and kind of move back towards the rear of the lot, you do see a pretty significant fall as well. You can kind of see where we pick up from what looks like one structure in the front of the house, or one story in the front of the house, to that subterranean basement. So we've got a pretty significant slope as well. But other than that, it's really just a need to get away from that sewer easement and those drainage problems that we've had. We've gone as far as to meet with the neighbors, and really their only concern about the project was just that we weren't planning on putting up 3,000, 3,200 square foot homes. We're planning to develop, within the scope of the neighborhood, which is closer to 2,200 to 2,400 square feet. But in terms of closer to the road, planning's already requiring us to have a shared access agreement along the existing driveway that will service all four properties. So we won't actually have any access to McGavick itself.
And did I understand Joey correctly, assuming you got the variance here, you still need to go back to planning for the actual subdivision? Is that correct?
Yes, sir. We are on the docket for next Thursday.
Okay.
Can you clarify something for me? I'm hoping that I heard this correctly. Did you say you're having? Is it along the property number? Joey, can you put the side map back up for me, please? Thank you. Okay, so your shared access will be coming off of where?
It currently, you can see where the existing driveway is, kind of right there in the dot. Well, it really kind of follows the sewer easement as it is. Okay. So really, that's an asphalt driveway right now that
so you're
goes.
Going to keep that.
And we're going to keep that and extend it a little bit further to gain access for lots 3 and 4.
So ostensibly, it kind of becomes an alley for all four properties.
Correct.
Okay, that makes sense.
Sorry, I'm slow to the party. So you've got a sewer easement, a drainage issue, and a driveway all on the back of the property.
Hard to believe we bought it, huh?
Wow.
Has traffic and parking said anything about the setback? I mean, I know that area very well, coming down McGavick.
No, sir, they haven't said anything, or it hasn't raised any specific issues. I think when we had only access to the property via RD, not on McGavick, that maybe that quelled that issue. I'm not 100% sure, but like I said, planning did require, that was one of the conditions of the subdivision, was that we have a shared access agreement along the rear of the property. That there was going to be no way that they would approve any type of access to the properties on McGavick.
As far as visibility for cars coming down McGavick, with these houses sitting closer to the road, it's going to cut off any visibility of RD Avenue, and that's a terrible intersection. There's Riverwood Drive comes in below. So that's like 5 streets that come together right there.
Yeah, that is true. But as the house that currently sits there, again, we haven't really got any direction about that, nor any kind of kickback regarding that. I guess our direction from them was more or less the traffic that's created by the 4 additional houses that are there, not the impact that we would have on the street itself.
I'm not talking about the addition of traffic. I'm talking about the visibility of RD Avenue, of creating a danger cars coming down McGavock and not being able to see cars coming down RD because of 4 houses there now instead of 1, and those houses being even closer to the street. You couldn't subdivide it into 3 lots and maybe set the houses back, or just your goal is strictly to get as many buildings on the lot as you can, or what?
Oh, our goal was it's currently 2 legal lots, and we felt like the lot size itself, I believe it's over 30,000. I think it's closer to 35,000 square feet lot. We felt like the development itself supported the 4. We did not strongly consider the blocking traffic from RD. No. That's just not, my apologies there, but that's just not something that we did strongly consider that traffic would be blocked. But again, we did meet with the neighbors and discuss the project at length with them, and that didn't seem to be an issue that they raised to us. So I guess it just never made it to the forefront.
What you're talking about.
But as a developer, don't you feel like you owe responsibility to safety of the neighborhood? You're going to build houses?
I do.
Okay, so I guess the question is, have you talked to traffic and parking already about this?
Only to the extent of the traffic that we've created, not regarding blocking any view.
Looking at 5 feet, I don't see that there's a huge difference there, but I guess this is an issue that they would have considered, considering what the traffic flow and accident rate might be around that corner. So, Joey, can I ask you a matter of form? Is that something that they'll consider?
But we're not talking about 5 feet. We're talking about 10-foot variance, correct?
From what the current house is sitting is 30 to 35 feet?
But the current house is way back from the corner. It's not going to be right down at the corner.
I see what you're saying.
That's my concern.
I see what you're saying. I guess that's a question, Joey. Is that something that they would consider, or do we need to have that evaluated?
I don't know Public Works' involvement in the subplat process as it relates to visibility.
Would that be a traffic and parking issue?
Yes, sir. It'd be Devin Doyle and those traffic engineers, those 4 guys over there. We don't, as a matter of course, send these types of appeals to them for comment. Not on a single-family residence.
So you're saying they haven't seen this?
No, they have not seen it. We would not have sent this over to them.
So is the subdivision dependent upon these variances? Or, are they saying that they need to come back with these variances before they'll grant the subdivision?
Yeah, and I'll let you cover this, but my understanding is with the subdivision plat being filed for 4, they were requesting 30-foot setbacks be recorded on the plat, and the base zoning won't allow for that. It has to be 40 on them, and that's why they're approaching you in the process of recording a plat of, if you grant these variants, then the Planning Commission will record those setbacks on this drawing. Versus some language they'll usually stick on there that says to be determined by the codes department.
So it has to be 40 to get the subdivision?
No, they're not mutually exclusive. They can record the subplat and then come to you. I think they were sort of directed by planning and staff to seek the variance side before recording the subplat, but they are not tied to each other. You can subdivide this lot into 4 lots and then come back and ask for variances if you wanted to.
So, but if they come to us second, it is a 40-foot, and they have to ask us.
Yes. So it's sort of I guess the economy of doing it all at once rather than doing it in 2 parts.
Okay.
And I'm not opposed to the subdividing the lots. I'm just concerned about coming to 30 feet from the road, especially, and bringing things right down to that corner. And I know that corner well. And
you're concerned more about lot number 1 or house number 1?
Right, and 1 and 2 specifically. But primarily lot number 1, yeah.
Because of the view, if you were coming down RD, and then there's these 2 streets that come together, Riverwood and McGavock, just kind of right there in a point.
I'm talking about McGavock comes downhill, coming to the left. RD is coming downhill into that corner. Cars come down RD, it's like the Indy 500. If you don't happen to see the car coming down RD and you're at the intersection, they come into that intersection all the time. So I'm just concerned about I've seen several accidents down there, I guess.
Joey,
right there. See that?
Joey, to address on this upper left-hand picture now, you just that one right there. The house across the street that is on McGavick and RD. How far back is that one from the road? Because those are all like in a line, right?
They're fairly well in a row. David, I'd be guessing, to be honest with you.
I mean, this just as a response to Dick's question. I mean, you know that I guess it looks green to me. The little brick house. You know, I'm just trying to get a sense of what 30 feet is in the vacant lot that we're looking at in the foreground, which is where that lot number 1 is. That's correct?
Yes.
The magnolia tree is lot number 1. Yes. And so where's 30 feet, and what that would illustrate your point, I think.
And is the pavement where the setback starts, or it's not, is it?
No, the setback would be up here at the right-of-way, wherever that is. Probably somewhere about where that...
Joey,
I'm sorry.
Can I ask a remedial question? Because I'm confident that Public Works is going to speak to this at some point. When in the process do they speak to it? I mean, they haven't spoken to it now, but do they speak to it during the planning process?
If they had an involvement, it would be at the subdivision plat level.
Okay.
Typically, Public Works will comment on issues that are presented before the Planning Commission. So when this goes to the Planning Commission, Public Works would have studied this, and they would comment on the traffic and the access issues.
I mean, I guess it goes a little bit to that question that we've had before of, you know, what is the plan, and is the plan appropriate for the space and this, and you know, you can approve it today, but it leaves as an ambiguity what it does to the safety of that corner issue that you're talking about. But if it were, and I don't have any issue with it being subdivided either, it seems to make sense. The councilperson is for it, but you know, it seems like each of those plots of land have different variance needs almost. I mean, like the number 4, I don't know why number 4 has to be 30. I mean, it's a huge lot.
They might all look funny.
Yeah, they might.
You know.
But you know, and why 30 versus 35 where the current house is? I guess that's a question for the.
I also have a remedial question. Do we know what the side setbacks are on each of these properties? Yeah, internally.
In between the lot lines themselves would be 5 feet.
Okay.
Well, let me ask you this. Actually, sorry, I'm asking questions I mean, I feel comfortable in saying I'm not a traffic and parking expert. I mean, I'm comfortable with that.
I also feel comfortable saying that you're not an expert.
Okay. So, I mean, to me, it might make some sense that if we want to see how the subdivision is going to be done prior to considering the variance versus us going first and being the trigger to the process, that makes some intuitive sense to me. Now, I'm sure planning had a reason for pushing it to us first. I don't know what that reason was, but they did. So I guess I'm comfortable as a board saying, hey, we'd like to go second, but I'm really not comfortable with us saying no because of potential traffic and parking that we can't know, that I can't. Well, maybe y'all I can't know.
I don't know. We're not really in discussion period, but and this can be rhetorically also directed at the applicant. I'm uncomfortable without approving it. I'm actually uncomfortable considering it without some idea of the master plan rather than the lot, because I mean, if we're talking about hardships, I mean, yeah, there's these things in here, but there's no evidence here as to why it's a hardship. You know, if they say they're doing 22 to 2,400 square feet, and you've got the 5-foot setback and all these other setbacks, that doesn't leave a lot of room for a footprint of that. But if it's a 2-story building, there's a lot of room to move around in the lot. So I'm not convinced. There's no evidence that it is required to have these setbacks to make the square footage work.
But hold on, I'm the guy who started this sin. Unless we have any other questions for our applicant, should we close the public hearing? Anybody have any other questions for the applicant?
Well, I will ask you, is there a plan, a master plan for the site?
Well, we felt like, not wanting to put, I guess there's two schools of thought here, not really wanting to put the cart before the horse. We have so many challenges with this property from a drainage standpoint and a extreme topography. There's a pretty significant slope there that, without really understanding what the subdivision would look like. I mean, we're in the preliminary process of developing plans. They are going to be story and a half, not true 2 stories, because that's not really supported in that neighborhood, just sheer building height wise, but story and a half, like I said, 22 to 2,400 square feet. And in all reality, we probably, I can't say this beyond a shadow of a doubt, but not sure that we would utilize the full, put the building as close to that front setback as possible. But we get into, not knowing where, and for the purpose of uniformity, asking, we know that we've got some topography issues, Lot 3 and Lot 4, and we do have this stone line natural spring that comes up from the earth that kind of splits the lot, starting really kind of where that sewer is and going straight across. So that the back part of Lots 3 and Lot 4, they're not buildable. We just can't, it's just not possible. So from our standpoint, we were looking for the variance for uniformity purposes, and then again, knowing that our intention was to build 2,400 story and a half structures. It's not necessarily that we were looking to, slam the buildings all the way up to the front of the lots. It's just we're looking for a little bit of leeway to not have to be at 40, because 40 puts us, in that uncomfortable range, being close to that sewer easement, and then those drainage issues that we have on the rear of the lot.
Who asked for the 30 feet? You all? The developer asked for the 30 foot? Or was that something the Planning Commission suggested?
We asked for the 30 foot. It's something that we derived with John Hood, who's the surveyor in this case. We're looking at uniformity across the lots. You made an interesting argument about, does each lot necessarily dictate a 30-foot setback? And I would agree that probably each lot is a little different, because it's just such a strange, irregular shaped with some topography, easements, and drainage issues that you can make a case that each lot has its own individual setback need. But we believe that the 10-foot request would help us achieve without having to really get into the specifics.
I personally feel that this being an appeal board, that we need to have some basis for an appeal rather than just a blanket. Let's change the zoning or the setback based on a subdivision plan. I just feel like we owe it to the city to see something, rather than just we've seen what happened before without knowing what was coming. That's my point.
Joey, what's on the property? The property to the northeast-ish, at the corner of Janey and McGavick. Is there a house?
There's a residence there.
Does that show up on the aerial?
Yes. There.
Okay.
And that one's further than 35 feet back, since the house and the property we're talking about is 35 feet.
Yes. I said that, that's a guess of mine. That house is clearly much further back than that.
Do we have any other questions for the applicant?
Would you consider a deferral to bring back a plan for us to look at?
What's the time frame on that? Like, for instance, how long does a deferral work, if you don't mind me asking?
It's negotiable.
Joey, when's our next meeting?
Our next meeting would be May the 2nd, 2 weeks from, is it 2 weeks from today? Yes.
Or it can be longer. I mean,
we would probably need approximately 30 days to put together the exact plans. They're in process right now, but they're not all the way formalized. There's still some meetings with architects that need to happen before that can happen.
Yes, there's no doubt we can put him at the top of the line. I do think we have a philosophical issue. I mean, because
It's going to help him.
right. I mean, I think. Well, I tell you what. Any other questions for our man? Okay, then we'll go to public. I mean, we'll close the public hearing and go to discussion. I guess I'm back to my original point. I get it if this board doesn't want to go first, and we turn to planning and say, tell you what, tell us what the subdivision is going to look like before we're asked to bring it. Now, I think what's going to end up happening is the developer is going to say, well, I don't know whether where my setback is, so how do I develop it? And I guess the answer to that is Plan A and Plan B, and go before the Planning Commission and either take on faith. Well, I don't know. I guess they have to have a Plan A and a Plan B, and maybe the Planning Commission won't grant the subdivision under that.
Well, I don't care if we go. I don't particularly mind if we go first or not, but I would like to see some plan that says, here's the approximate footprint, because if I were making the motion, I would be saying, within these footprints, within some, because we know I'm not asking them to design the houses, but I mean, you're going to have some idea of what a story and a half for a 2,400 square foot house looks like, and that would illustrate. There's nowhere to put this on the lot unless I have this setback. You know what I'm saying? I mean,
let me ask you this, because I think if we're going to ask them to defer, we can at least give them a little bit of guidance. Speaking only for myself, I do see hardships. I mean, you've got drainage, you've got easement, you've got a driveway. I mean, I see hardships. So I'd hate to ask them to go draw a bunch of stuff if nobody else sees it but me.
I mean, I see hardships, absolutely, but I respect the comment that said, if you're building a 2,000 square foot house, there's a whole lot of ways to build a 2,000 square foot house that'll fit within a setback further than 30 feet. Maybe it's 35, maybe it's even 40, like it's supposed to be, and to make it work. And so, I think that, to me, what I heard, and again, just what I heard from the comments, was that at least some balance of that is more appropriate. I mean, I think, if it's going to be 30 feet, then that lot number one should absolutely address the security issue of RD Avenue and McGavock Pike in terms of sight lines, and if it doesn't, there's probably a problem. But to me, what I heard was that 30 might be stretching it, and pay attention to that corner and be creative in how you build a 2,200 square foot house and come back with a plan.
Well, so then also, if we're going to ask them to go do the plan, do we also want to ask them to accelerate talking to Public Works about the traffic issue? Because I mean, if they do a plan, it makes sense to me that if we're worried about traffic, we're going to get them to go solve that problem first too. Does that make sense to?
Well, I think the fact that it is our responsibility and in our purview to deal with public welfare, as far as safety is concerned, with traffic issues. It's our duty to ask that question.
Okay.
Don't you think?
Let me ask this question. Our legal guidance is not here, but
John Michael, what do you got to say?
Bill, have you got
example,
any thoughts on that?
Does this board take precedence over, like, traffic and parking? If traffic and parking came along and said, we don't recommend that, and this board grants a variance, who takes precedence?
Well, traffic and parking is not something that this board has jurisdiction over.
Right.
Is it informational? Yes. Could it weigh into your considerations of what you would think would be the appropriate variance on a setback? Yes. So is it relevant? Yes. Is it something that you could consider alone as a criteria for a variance? No. I hope that answers your question.
It does. I guess I'm asking if we granted a variance in traffic and parking, came back later and said that you can't build a house there because of the sight lines. Could the appellant say, yeah, but I've already got a variance?
No, I think
he says I can build within 30 feet.
Where it would probably come into play would be where traffic and parking / public works would weigh in at the planning commission during that process, determining how these particular lots would be platted out. And during that process, if traffic and parking felt like the site distances were an issue, I think that would all be vetted out during the platting process in front of the planning commission.
So it will be a consideration. So our discussions today, if we granted this, would not indicate that because we've said he's got it, that he's going to be able to use it.
Correct.
Okay.
Oh, I'm sorry. Go ahead. Well, and I guess just back to my theme of the day is that if we granted this variance, and all of a sudden the property owner decided to sell it, and somebody else came along, maybe a big church like the one across the street, and wanted to build something that's appropriate for a residential neighborhood. I mean, I guess that's why, to me, it's a little more appealing to have a master plan that we can say, no, this variance is appropriate for this master plan given the hardships that are clearly on this piece of property, rather than doing something blanket that may not actually happen.
So if we, I'm sorry, go ahead.
Why can't we address that? I mean, to your point, and because we just walked right through this a second ago in the last case. So, to your point, can we address that as a condition of this particular owner's intentions?
Yeah, I mean, if we grant the setback and they don't subdivide it, does the setback? Because we're granting a setback to something that doesn't exist. Yet.
Hold on, y'all correct me where I'm wrong, because I do want to make a differentiation here. The special exception that we talked about previously, that doesn't necessarily travel with the land. I mean, they were back talking to us for a purpose. My understanding is the variance does travel with the land, and so we ought not get too terrified that people are going to not do what they say with a special exception because we're granting that
wasn't my point. The point was what David brought up about the variance question that we have dealt with now a couple of times where he's seen a project come before us.
Right.
They've given us an indication about what they're going to do, and then that doesn't occur. And so there's that moment where we're stuck between trying to do the right thing by somebody trying to subdivide the land, and where we're also a part of setting a precedent of developing property in a way that isn't intended in the future. Do you understand?
I do, and I don't want to be the poor man's John Michael, but I think that's a concern with variances, not with special exceptions.
Right.
That's my.
That was my point.
That's my sole point.
So, yeah, and the point is that this is more likely to be impacted by my concern than the other, and so I'm just saying I'm not at a point where I can support just a blanket variance without seeing more.
Because to subdivide it, then there is a hardship. Presently, there is not a hardship.
Right. That's right. Mm-hmm.
Okay. So that would be a self-imposed hardship, So
and I'm still curious to know for this specific case and in general, since this does not exist. To whom are we granting? To what piece of dirt are we granting the variance?
That property bound in red.
So it's not to the individual.
So somebody, the current owner or anybody else could say, I'm going to build a big old thing.
I hate to jump ahead, but I feel like we're all saying the same thing. Aren't we going to suggest to the developer that they defer as long as they need to bring together a plan and run that plan by Public Works in advance? And I'm pretty sure they would want to bring in planning, but that's your choice.
I think it's going to be in his best interest to defer it.
But we need to actually make the deferral, isn't that correct, Joey? So that there's flexibility as to when it's scheduled.
So I'll make a motion that we defer this case for 1 month to the meeting of whatever that second meeting of May is, May 16th.
That'll help you.
And that could be extended if you needed to.
I'll second that motion.
We've got a motion. We've got a second. All in favor?
Aye.
Any opposed? Passes.
There you go.
There's some dead horses laying around today that we've just been kicking and kicking.
Editorial note. All right, let me give you an editorial note. This would be an example where I'm talking about dirt versus land. If they brought in a plan and it showed a 3-story house and you didn't like a 3-story house, you don't need to consider that because the stories have nothing to do with the setback. Or it's Tudor versus, all right. I understand, but that's my concern as your secretary to you. Don't get into the design. Okay.
We cannot become police to people's integrity issues or any of those matters. I think we run the risk of becoming, it's a slippery slope of anticipating that people are not going to be integrous when they walk in front of this board. But there's also a position that conditions change and we are in an interesting financial situation, and I think we have to also be prudent with what we do.
And we also run the risk that we're forcing people into SP zoning, which is not our job. I mean, we are not the council. And so, I mean, I think I'm all for, I'm all for what we just did, but I don't want to see us go too far and we're acting like a zoning board. I mean, well, appeal, planning committee. No, or the council. I mean, they're the ones who pass SP, not us. So.
Okay. Final case today, case 2013-27. This case was deferred by the appellants. The ING Elston Incorporated, the appellant and owner of the property, is located at 2110 Elston Place, requesting a special exception for street setbacks and height and sky plane. Those would be along 21st and Elliston, and a variance in rear setback in the MUGA district to construct 21 Elliston apartments. This project consists of 62 one-bedroom and 43 two-bedroom apartments. Referred to the board under section 1712.035D, 1712.060F, 1712.030. The appellant has alleged the board would have jurisdiction under section 1740.180, items B and C. I know the appellants are here. Is any parties present opposed to the case or also in support? Okay.
Joey, could we take like a 3-minute, 4-minute recess before we start? Is that
completely
Chairman?
Up to you guys?
Yes.
All right.
Just bear with us.
The board will take a short break, and we'll be back in just a few moments. If you can see where my cursor is, that would be along this property line here at the narrowest point of these two parcels. This is the aerial photograph of the property. To orient you, Baptist Hospital to the northeast, also to the southeast. Good old Krispy Kreme down here across the street from the site. Parking garage for Baptist, and then as you get into Elliston Place and the shops out there. That location. These are the two properties involved today's appeal. The special exceptions are on the street setbacks along 21st and Elliston, and then the rear setback would be along, as I said, along this of the narrowest of the two lots. In this area, they're requesting a 5-foot setback and then 4 at this location. I'll revise my number at the top to read 4 here. This is the current use of the property, former dry cleaners on the site, and the vacant lot, which you see here. And then views along Elliston Place, looking toward the west, and then looking south toward West End, and then the adjoining property to the east. This is a view. These 3 photographs are a view. I'm trying to encompass all the site together, but sequencing 21st would be here, heading west into this portion of the building. You see the doctor's office complex is to the rear. The adjoining building here is an optometrist office here. This vacant lot, this area here, are all the subject property. And then the variance location would be located along the property line that separates the cleaning, the old cleaners, and this parking garage here, as you'll note, the existing building at least appears, upon my visit out there, to be actually closer than 5 feet to that property line. If it's a 4-foot stretch of chain link fencing there, it's approximately 4 feet from the rear property line today. This structure is going to be raised. The new structure will be built in place. You have sitting before you at the ground level elevations submitted by the appellant. The color renderings there, I've talked during the break. They're going to shoot over a copy for an electronic record, so we'll have those on file too. They have submitted some preliminary elevations. I'll pass that along to you. We recently received some new equipment in our office, so many of our scans are not quite scanning properly. So once yours truly figures that out, we'll
user error.
I will blame ignorance on this, operator ignorance. We've received a letter from Council Lady Edith Langster saying that she attended several meetings, held a neighborhood meeting, and there was unanimous support from all the residents that attended that meeting, and Ms. Langster is in full support of the request. The applicants have submitted a brief. That is part of the record as well. And with that, guys, I will turn it over to you all for your review.
Mr. Chairman, members of the Commission, my name is Tom White. I represent the applicant in this case. To my left is Joe Herman. The architect to my right is Jennifer Spike, who's the engineer. As was commented, this involves a special exception and also a variance. On those two issues, as you understand, under the special exception, there's a requirement by this board that you have a neighborhood meeting. As was commented by Mr. Hargis, we had that neighborhood meeting coordinated with Edith Taylor Langster, the council person for this area. The meeting actually took place at the site, in the dry cleaning building, which you saw in these slides has now been torn down. But the end of the story is at that meeting we had significant neighborhood involvement. We did a full presentation at the meeting, and every single neighbor that came indicated their support, not only no opposition but total support. The bigger property owners in the area, some of whom did not attend the meeting, had previously indicated not only no opposition but total support. With respect to the meetings that the council lady mentioned, my client and I met with her on a number of different occasions. Again, as she got feedback from her constituents, she remained totally supportive. There's an MUGA zoning here. It's got a UZO overlay. This particular use, which is apartments, a total of 105 in number, are clearly allowed. There's no issue there about whether it's permitted or not. As was indicated by the staff, the Planning Commission has recommended approval. Public Works has recommended approval. We don't know of any dissent from any metro agency with respect to anything. This, first of all, with respect to a special exception, and without going through the 5 or 6 page legal brief that I submitted, I'll make these comments. As a special exception, the key thing you look at is, are you basically doing anything adverse to the neighborhood? And it's relatively clear here that can't possibly be the case because it already allows this type of apartment complex, and we are below the height limit. So I think that answers itself. With respect to the general conditions, again, you look at whether or not it has an adverse impact on the neighborhood, whether or not there's a traffic issue, and is there infrastructure in there to support this particular matter. Now, I think as most of you know, Council Lady Langster has a zoning bill currently moving forward on Midtown, and it's driven by the very type of thing that this project answers, in that they expect by the year 2035 1 million more residents in Davidson County. A great number of them they see in this particular area. Midtown's become key. They're looking for this type of density, this type of unit there, and frankly, if Council Lady Langster's bill passes, which I'm confident it will in less than 2 months, we wouldn't need to be here because all these things would be allowed by her bill. She's totally supportive of that zoning bill as well. With respect to the requirement for the variance, narrow, shallow, et cetera, you've seen the diagram that was put up there by Mr. Hargis. I think that also speaks for itself. If we can let Mr. Herman do a short presentation on the elevation, we'll do that and then answer any questions.
Well, let me pull this up real quick.
And sir, if you'd like to, you're welcome to this podium here.
Yeah. Coordinate this. So we're right at the corner of 21st and Ellis. trying to create just a lot of excitement, taking what is currently there as a blank wall for the parking deck and making it into a much more vibrant edge feel. We've juxtaposed, its site considerations with where it transitions from Church to Elliston and developed that into plan as well as in section, as well as in plan and in elevation to try to give a little bit of a kick to address that slight turn in the road. We're going to use a lot of high quality materials. The building is basically 5 stories over 1 story of loft units. There'll be double height units, similar to what you might have seen at Velocity, if you're familiar with that project. And we think it's going to be a great project.
Questions that generally most people are familiar. There's some great history on this site. One of your board members is particularly sensitive to it. This was the residence of Ann Dallas Dudley, Guilford Dudley's mother, who was such a key person in the passage of the 19th Amendment for women's vote. According to most historical accounts, a lot of the meetings took place at this site. And the owners of the property were aware of that when I was informed about it. And as I said, one of your board members is particularly sensitive to historic things in this city. The client was already aware of it, and so I know that they plan on some appropriate naming that will represent, whether it's the yellow roses or whatever it is, it'll take that into account. My very last comment before we take questions is that one of your wise board members, Dick King, said earlier today, good things happen to people that wait. We've waited to last, and we'd appreciate your consideration. Thank you.
Well played.
Yeah, where's the parking in the building and where do you enter?
The parking is actually in the back and underground.
And we more than exceed the parking requirements.
So what we've got is vehicular access here, we've got parking garage in the back. The street is all fronted with units. We've also got vehicular circulation along the backside here next to the parking deck at this ground level. And then up above, we go to residential units. Over the parking area over here, we'll have a pool as well, a little courtyard.
And then how tall, I know that according to the drawing that it's you have a 6-foot setback from the street, and then at some point it goes to a 0 setback. How high are you before you go to 0?
About 20 feet.
Okay, I was just curious.
It'll vary. The site slopes a little bit, but 20 feet is the minimum.
I'm just going to say this. I'm going to a la David Ewing's typical approach here, but I really want to commend the design of this project because I'd like to see Elliston really become a more pedestrian-friendly area, and having a place for people to live and feel secure and kind of vitalize that area is a great opportunity here, and you guys have done a great job in approaching that intelligently. So I want to commend them.
Jimmy Kelly's and Krispy Kreme love them. Do we have any other questions? Okay, unless we have any other questions, I'm going to move to close the public hearing. Okay, close the public hearing, and I am going to be bold enough to go ahead and make a motion because I think we should grant the special exception because all the criterion of MCL 17.16.150 have been met, and I would propose that we grant the variance because of the shallowness of the lot.
And I'll second that.
Mr. Whitson, for purposes of record keeping, and I need to update your thing there. With the council's change of this section, I've said too much, but long story short, instead of 150, it'll be 17.12.035 of the code, because that's the section you guys look at for these.
I always do what you say, so I amend my motion.
Okay, and that's acceptable to me.
Okay, so we've got a motion, we've got a second. All in favor?
Aye.
Any opposed?
Passes.
And before we leave, I'd like to say one thing about one of our greatest Tennesseans of all time, Ann Dallas Dudley, who was a Ward Seminary graduate. Tennesseans should really embrace what she was all about. This was a very prominent woman from a prominent family that believed that women should have the right to vote. And she, as mentioned by Mr. White, she lived on this site in a nice house back then, and she organized women, the first women's suffrage parades in the South in 1914, so almost 100 years ago. She boldly walked with, almost 1,000 people from the Capitol to Centennial Park in honor of women's suffrage. And it's a tribute to her that this building hopefully will be in some sort of honor for her and the women that fought for this. And it's just very nice. Her house sadly was torn down, I think 40 or 50 years ago. The Dudleys moved over to Hunter's Hill, but this is a very nice project, and thank you for doing it.
On the back end of that, I just want to say, as the president of Women in Numbers, which is about endorsing a nonpartisan organization endorsing and supporting women running for political office, I too love to see that this is an opportunity for us to celebrate one of the greatest moments of our history. So thank you so much for making that a consideration.
Okay. With that, the Board of Zoning Appeals is adjourned. Thank you.